To go. So welcome all to the second in the St. Philip's Chambers Real Estate webinars. I shall be providing a short and swift update on proprietary estoppel and a couple of key cases and what we can take away from the same. I'm also joined by Attorney Verduyn, who shall be providing a very useful talk on mediation and evaluation in property courts and tribunals. Please do use the chat function at the bottom of the screen. I will endeavour to go through some of the questions that you raise, and if not, we'll reply by email if necessary. So we'll get cracking. So why am I talking about proprietary estoppel today? Well, particularly since 2018, there has been a marked rise in proprietary estoppel claims, many of which have reached trial, some being more conducive to alternative dispute resolution. And indeed, one of the cases as set out on screen, Guest and Guest, reaching the Court of Appeal and currently on its way to the Supreme Court. So I'll be discussing in brief what proprietary estoppel is to give you all a little bit of a reminder from the old equity and trust law school days, followed by briefly looking into Guest and Guest and another key decision, Wills and Surrey from last year. So as you can see on screen, and I'm sure you'll all be aware, proprietary estoppel is essentially a discretionary equitable regime or a set of equitable principles pursuant to which the court may interfere with legal property rights and provide a means by which legal property rights may be acquired or affected in some shape, way, or form. The aim for the court is, for the benefit of the party asserting proprietary estoppel, to stop the other party from being able to assert strict legal property rights in situations which are unconscionable. You see on screen that I've set out a roadmap of the key principles that need to be satisfied to ground a claim in proprietary estoppel. And essentially, an equity arises where the owner of the land induces, encourages, or allows the claimant to believe that the claimant has or will enjoy some right or benefit over the owner's land or property, provided that the inducement is not specifically limited to mere personal use of that land. And in reliance upon that belief, the claimant acts to his or her detriment, to the reasonably determined knowledge of the owner, and the owner then seeks to take unconscionable advantage of the claimant by denying the claimant that particular right or benefit promised. So we go from representation, reliance, through to a detriment, and at the end, and it's the key component, is the relief that the court can award, which is what the two cases which I'll come on to discusses in length. So brief touching upon the encouragement or acquiescence, the representation aspect. This can be by words or conduct, can be active or passive, and the owner must have been aware of or should have been aware of his or her proprietary rights, something which that person can give away. The property rights themselves do not have to be specific, as long as it's ascertainable at the critical time, i.e. when the representation is made, and can apply to property that's not even yet acquired. That, for example, a promise or inducement that the claimant was to inherit the owner's residuary estate, for instance. It can even relate to the release of a covenant, an easement over the claimant's land, but again, it cannot be a personal right. Then you go on to the detrimental reliance, and that can, for instance, and we see this all the time in the factual matrix that usually makes up proprietary estoppel, for example, in relation to farming land and family members, is the expenditure conducted on the property itself, working at a certain property for a number of years on reliance of a promise, giving up certain opportunities, and that's what the court looks to in determining whether a particular individual, the claimant, has fallen to their detriment. The reliance aspect has to be disproved by the defendant if there is an element of encouragement and detriment. For example, did the claimant act on independent advice? Was the claimant motivated by something else? Although that doesn't necessarily preclude the finding of proprietary estoppel if there is some element of motivation coming from elsewhere. But again, the owner's intention is irrelevant, and you're looking objectively to see what is reasonable for the claimant to have relied on the assurances. Then the court comes on to the key component, relief, and there is a wide discretion available to the court to satisfy the equity, essentially to avoid an unconscionable result. The court looks to all the circumstances of the case, the expectations and conduct of the parties, and can award a negative form of relief, so restraining an owner from asserting strict rights, or a positive form of relief, for example, ordering the owner to convey some estate right or interest over the property, or pay the claimant some sort of compensation or act in some other way. So as I say, the key component that permeates through these principles and shows why this doctrine is very flexible is the concept of unconscionability, which still remains to this day not well defined. But essentially, you're looking at whether it's unjust to let the defendant who made the promise get away with it. So given the flexibility of proprietary estoppel, in terms of the factual situations that may fall within its scope and the remedies that the court can award, necessarily means that the outcome in relation to proprietary estoppel can be predictable. So one may think that it's not conducive for these matters to be settled. But on the same token, one has to realize that given that it is unpredictable, ADR may be a better option than taking the case all the way through to a trial, where you do not know the relief that the court may award, even if the three key components, representation, reliance, and detriment, has been satisfied. And as I've put out on screen, given the unpredictability, it may be prudent for the practitioner to think about the state of the evidence at an early stage as possible. What is the state of the evidence? What is the likely state of the evidence going to be, particularly when you're relying upon oral evidence? And will the case turn on the finer points of evidence, which usually it does? And how can we best use the case law to our advantage? Each case does turn on its facts. The cases, when we look back to 2018, each one is different from the other, but there's some learning to be taken out from them in terms of, for example, procedure, evidence, or the way in which the courts will look into the relief component, which, as I'll come on to, is the key part of it. So, turning our attention to guest and guest, as you can see, I've set out the three things that a practitioner should be aware of and sort of the assistance which we get from guest and guest to manage client expectations. So in a nutshell, this case involved a farmer who had worked on his father's farm for over 30 years. Modest pay was given for the services, and he believed that his parents would one day allow him to inherit a proportion of the farm, or at least that was the promise that he was given. In this case, there was family turmoil in a way and a breakdown in the relationship. The judge at first instance held that in order to achieve a clean break, the farm should be sold and some form of a lump sum payment should be given to the son. So what was awarded was 50% of the value of the farming business and 40% of the market value of the farm itself. So let's assume that the elements of proprietary estoppel have been satisfied and an equity has arisen. How does one determine how the equity should be satisfied? How does one determine how to satisfy the client's expectations? And what should a court award? Quite a few mix-up of various questions for the practitioner as a result. So this matter did go to the Court of Appeal, and an application for permission to appeal to the Supreme Court has been granted, so do watch this space. However, the principles relied upon by Lord Justice Floyd in the Court of Appeal are of some significance in determining the appropriate remedy, and it follows the long list of case law that I've discussed in relation to 2018. Of course, we can't go through each and every one of them today at all, but it may be worth for the practitioner just to have a look through Westlaw input in 2018 proprietary estoppel and see what comes up, because it will be of assistance. Lord Justice Floyd found that the task of the court is to do justice and that there must be a proportionality between the expectation and the remedy and the detriment that's been suffered. And that if the representation is in reasonably clear terms, then the starting point is that the court will satisfy that particular expectation. But if the expectation is uncertain, or it's not proportionate to the detriment which the claimant has suffered, the court could satisfy the equity in some other more limited way. So in this case, the court rejected the suggestion that the son should have been awarded a sum that merely reflected the increase in value of the farm, but the assurance was clear enough that he would inherit a sufficient interest in the farm to enable him to farm there for the long term. It's a unique case in the sense that this particular promise was made on the back of the suggestion that he would inherit the farm once the parents had passed away. But given the relationship between the parties had broken down to achieve a clean break, that remedy was essentially accelerated to enable him to take some interest in the property and subsequently sell the same. So what we learn here is that the focus is upon the promise made. What is that promise? What is the client's specific expectation? Is it clear enough on the facts? If it isn't, how else can we manage the client's expectation and provide a suitable remedy to avoid essentially an unconscionable result? Here, if the son had not been awarded what he was given, then essentially he would have been disinherited completely. So that shows the unconscionable result without the remedy the court did give in the end. One has to think sometimes outside of the box and a bit more creatively when preparing a case of this nature from the outset to determine whether some other form of monetary reward might reflect the interest of the property promised, whether sale of the land is more appropriate, or a license to occupy that land, the provision of some full or partial beneficial interest. But again, that all depends on the factual situation you are faced with. So for the practitioner, if there is enough clarity on the remedy when approached by a client and once the facts are elucidated, and if the merits support the case on the other elements of the doctrine, then settlement clearly becomes a more conducive option. So the three options that are put out on screen, or the three questions put out on the screen, are the important ones. What remedy does the client seek? On the facts, is the court like to grant this particular remedy? Or is an alternative remedy open to the client? So you approach the matter in a more creative fashion, but obviously it has to be grounded in reality as well. Another key case is wills and sore. So in this case, we have a claim in proprietary estoppel brought by two brothers, Matthew and James Wills. The deceased, Mr. Sore, had died interstate, and because the brothers were not related to the deceased, they did not benefit pursuant to the intestacy rules, and the sole beneficiary of the estate was an estranged daughter of the deceased, Claire. The deceased had made a number of promises to the brothers, and so they pursued a proprietary estoppel claim. The daughter was the defendant to the claim as sole representative of the deceased estate. And again, it's a unique scenario we face here because the brothers were not related to the deceased at all. There was a claim for specific assets in the deceased estate, namely, and the aim of the defendant was to prevent the land which both brothers occupied to be part of the deceased estate. Oh, sorry, the brothers tried to prevent that. The unusual feature here is that that the relief was limited to a specific parcel of the land in question. The deceased knew the brothers since they were children, whereas the daughter was estranged and only met the deceased when she was 22 years of age. And Matthew in particular had been given a number of promises, whereas with James there had been a specific transaction in place whereby he provided a vehicle to the deceased in return for a plot of land. In this case, one thing to note is that there were 5 witnesses for the claimant, 15 witnesses for the defendant, including an expert in evaluation. For Matthew here, the promise changed when Claire became involved, and some parcels of the land were now to be given to her. And it's important to note that Matthew acknowledged this in his oral evidence, and the judge therefore considered him to be a credible and reasonable witness, and focusing on the factual matrix, the judge understood that there had been some form of detrimental reliance. The oral evidence, once tested, and the daughter's relationship considered, the judge found in Matthew's favor and awarded him all the land and buildings that was transferred across to him to satisfy the equity. With James, it was a much more straightforward scenario. There was a transaction in place. He had built a home on the land in question and installed a number of features on that land. And so the court found in favor of James, and the whole plot of land was transferred over to him. Given the court's focus upon the oral evidence in the case and the credibility of the witness, and given the number of witnesses that were in this case, it is clear that the focus is upon the quality of the oral evidence given, upon which the case will pivot. So it's important for the practitioner to make sure that your witness statements are thorough enough to meet the tests to the point and reflecting that true factual understanding of that particular witness. It's important to avoid submissions which the court was in particular wary of in witness statements, and making sure that it satisfies the test in terms of proprietary estoppel in each of those elements, including the relief that ought to be given. Then it all comes down to the execution of that witness in the witness box. That might be something that's outside of the control of the legal representatives, but it must be conveyed to the client, and clearly it's determinative of whether or not the client should settle. The question is, what will this particular person or this particular witness appear like in the witness box? What's their recollection of in terms of the events, especially when these matters go a long way back and relate to intimate details? So the credibility of the witnesses becomes key. The court again looked at the question of remedies, but from a different context. In this case, an alternative remedy was submitted, but the court found it had not been pleaded and therefore was not willing to award the alternative remedy. So it's important that at as early stage as possible, you set down what remedies the client expects and are grounded in the facts and can be pleaded, and indeed it should be pleaded, to avoid the risk that it might be a tricky balance to achieve, particularly where it depends on what expects something other than expectation. The key there is to focus upon the client's expectation and not to go too outside of the box, but nonetheless find alternatives for him or her. The third key point is testing the evidence to assess the merits. And what I mean by this is, at an early stage as possible, is to look at the factual matrix and determine the factors which support your client and the factors that do not. It may seem that this is common sense. However, when it comes to a claim such as proprietary estoppel, where you're relying on oral evidence and recollections of events and discussions, is to know what is the court likely to find. And with a flexible doctrine such as proprietary estoppel, that's not always easy. To do the best you can, and in this particular case, given the number of witnesses that were involved, to determine whether or not this matter is conducive for settlement, or whether it should go to trial, the evidence should be tested by the practitioner to see what conclusion we reach. And as set out at the bottom, alternative dispute resolution, is it worth it in this particular case, in guest, or in any other case? We are dealing here with family members, from facts from a long time ago, certainly complex factual situations, a lot of uncertainty, and a focus on the oral evidence. In my view, proprietary estoppel claims are clearly a favourite for any form of alternative dispute resolution, mediation, for example. You're not bound by the tests, and these two cases that I've discussed have shown that relief is the key component that the court looks into. And when there is that uncertainty as to what relief can be awarded, alternative dispute resolution seems more appropriate. So you're not locked in to the legal test as such, and you can be more creative than usual, even for a proprietary estoppel case. So that's a short and swift look through proprietary estoppel and a couple of key cases and what can be brought out of them. I'll now pass you over, and as I say, there is the chat function at the bottom. I think I have one potential questions. I'll have a look at that. If there are any further questions, do drop a question in the Q&A. If not, my email address is on screen, and I'll endeavour to get back to you as soon as possible. I'll pass you straight over to Tony.
Right, thank you very much, Raghav. I think there were some problems with the microphone during that, and so I'm going to ask Raghav to interrupt me at any point if those problems are duplicated with anybody hearing me, because it is difficult for the speaker to tell what the problems are which are being experienced elsewhere. Raghav, if you can stop sharing your screen, then I can, I think, share mine.
Yeah.
That's better. Right. Let me just put on that to give everybody something better to look at. than me. So Raghav has spoken about proprietary estoppel, which is, as he identifies, a prime candidate for mediation, often because there's familial disputes with high emotions, but results can be unpredictable. Usually the money which is being involved is finite and is being swallowed up by the dispute, and there may be a variety of solutions which the parties will consider, some of which the court will order or may order, but some of which perhaps they won't. Now, as a mediator, of course, I am keen for my services to be retained. But what I want to look at today is how similar services can be obtained without paying a mediator at all. I'm going to focus particularly on the courts, but also the first tier tribunal property chamber. I do mediations for the chamber in both land registration and residential property divisions. Land registration all over the country, residential property typically in Birmingham, where there is a bespoke suite of rooms for mediations at the Centre City Tower. But I should say at this point, in great tradition of these things, that all the opinions I express are my own and not to be attributed to the tribunal. The tribunal services have been interrupted to some extent by the pandemic. I'll come up to that in a moment. But insofar as they have been interrupted, I know that they are intended to be restarted as soon as possible, and certainly in the months ahead. So I want to start by talking about the land registration division of the FTT. If you deal in disputed applications to HM Land Registry, then considering mediation is going to be important. The FTT behaves rather like the county court, and it's a cost-shifting jurisdiction from the date that the matter is referred from the land registry to the tribunal. Now, as I say, there's currently a suspension of mediations, but it isn't going to persist for much longer. I think there's two reasons why it has been interrupted. One is resources during the pandemic, and the second is there has been some question mark over success rates in video mediations taken through the tribunal. I don't tend to share misgivings about the latter. I think there's very good potential for mediation by video link, but as I say in the Chamber's video on YouTube, what to expect of video mediation. But I think there is a difficulty sometimes, particularly with side views and matters of that sort, where that can help in a mediation, but obviously cannot be done by video or remotely. But as I say, the tribunal is looking to restart face-to-face mediations as soon as possible. So just considering, first of all, when it will be offered by the first tier tribunal. Obviously, when somebody makes an application to HM Land Registry, there's a period where the Land Registry looks at whether there's any objections. Sometimes it can extend the deadline for negotiation where there are objections for up to 6 months. And before the pandemic struck, that was getting to be quite a strict deadline. Since then, they've been somewhat more flexible, I think, and things are being referred later to the tribunal. But at the end of the pandemic, we can expect service levels to be restored and for strict deadlines to be imposed. In my experience, it's rare for mediation to be part of the dispute while it's still at the land registry. And I think there's good reason for that. Parties might want to see whether the applicant or the objector blinks. In other words, whether they are willing to take it to tribunal or not. When it goes to the tribunal, there'll be a prompt direction for statements of case. And the statements of case will include key disclosure. And when both statements of case are in, the case is reviewed by one of the tribunal judges. And it's at that point that the tribunal itself will consider whether to offer mediation. And so if you're very enthusiastic about going down the mediation route and you want to save paying for a mediator, it's a good time when the statements of case are complete to raise that with the tribunal if you wish to. It might be a bit early to do it if you're the applicant and you just put in your statement of case because you don't want to perhaps appear too enthusiastic. But as it's a cost-shifting jurisdiction and costs are awarded on the normal basis reflecting the civil procedure rules, it could be relevant if you were keen to mediate and the other side refused to do so. The reviewing tribunal judge may not be a trained mediator. They will often refer cases where they think the case is weak, not necessarily so weak as to be struck out, and they may also offer mediation in cases where they think that costs are just going to be massively disproportionate, and that's not that unusual in land registration matters. Oddly enough, sometimes where there's a more balanced dispute or a more nuanced dispute, so say a determined boundary, for instance, where there could be give and take, sometimes those have fallen through the net. That's one of the reasons why I say that if you're keen to get to mediation, then you can raise it with the tribunal. Mediation is voluntary, but any mediator provided by the tribunal will be trained either, like myself, by ADR Group or CEDA in private practice, or through special training offered to the full-time judges following their appointment. And so the mediator that you get through the tribunal will be somebody who has a conventional training and generally have quite a lot of experience. There's no fee for the mediation, and the tribunal will ordinarily arrange for rooms or for some facilities to be presented. The mediation file is always kept separate from the conventional court or tribunal file, and if the mediation is unsuccessful, then that mediation file will be permanently separated from it. So anything that goes to the mediator does not end up in front of the judge. So that's great, and potentially it's very good. Here are the upsides, I think. Tribunal makes the arrangement. If you're in a case where there's a litigant in person, and quite a lot of litigants in person are involved in land registry disputes, it's quite handy that the mediation is effectively and doesn't involve the lawyers making those sorts of arrangements. You get specialists in the field, and as I say, there's a considerable cost saving. Quite often on land registration, you will find that the mediator will go to the location of the mediation. It was as a result of location where the party is resident or where the land is. That's when I discovered that in the website offering the top 10 hotels in Scunthorpe, none of the top 10 hotels in Scunthorpe were actually in Scunthorpe itself. The downside is this: you get no choice in the mediator. I'm often asked to recommend mediators for cases that I'm involved with in private practice, and I will choose or make a selection on the basis of some of the skills of the mediator. Sometimes you're looking for people with good client skills, which can be very helpful, calming clients and helping them, assisting them towards a conclusion. Sometimes you're looking for a mediator who will be strident and who will shout at your client in the way that you may have wished to have shouted at your client on a number of occasions. And I certainly have a list of mediators in the shouty school as well, when necessary. Limited time, you're not going to get late night settlements out of a judge. They're used to working normal court hours. They're only going to be paid for normal court hours. And so basically, if it isn't on the cusp of settlement by about 4:30, then the mediator might well call it off. Actually, I don't think that's necessarily a disadvantage. It certainly focuses the mind, and it's likely to be said at the outset of the mediation. And I certainly haven't experienced as a mediator in that sphere difficulties, which in terms of there being inadequate time to deal with things during the day. The litigants in person, I've said that the tribunal often has litigants in person. Sometimes they're running the wrong case or missing an important point. Sometimes if the mediator is a judge, they might struggle to maintain absolute neutrality in those circumstances, and I'm going to come to that further in a moment. The mediator in a judicial mediation seems to me also has an important trump card. they can make observations against the background of what they would do or what they would expect their colleagues to do in a trial of the particular issue. And I think there's a fine line and a difficult line between playing the devil's advocate, which we're all familiar with, and one of the reasons why you might choose a specialist mediator, and providing a form of early neutral evaluation. And the mediation service isn't supposed to be and isn't offered as early neutral evaluation. And so that can be problematic, particularly if, as I've said, the reference to mediation is for a case which is involves a party whose position is plainly weak or plainly weak and unrepresented, when it can be difficult for the judge to, as mediator, to toe that fine line between advising or warning, perhaps, and facilitating a settlement. And I think there can be a temptation for all judges acting as mediators to push the parties towards the result that the judge thinks would have arisen had this matter been tried. And I think sometimes the parties can expect that as well. I've certainly had mediations where at the end of it, a party has asked, well, if you had been the judge, what would you have decided? I can tell you now that I don't answer that question. Then the final drawback is the drafting of settlement terms. Tribunal offers proper mediations, and it's not for the mediator to draft the terms of settlement. But that can be problematic. Tribunals are not like courts. They can't make Tomlin orders because they can't enforce orders. And it's not unusual for a settlement to be bounced back by a procedural judge saying, oh, well, we need to change this or that, or you need to modify the terms of settlement to reflect the powers of the tribunal. So there are drawbacks and difficulties. They can generally be overcome. What if the mediation fails? As I say, it's unproblematic. The trial judge is never the person who's the mediator. And in my experience, and I have quite a lot of experience with this, I've never known any circumstance in which a judge who has acted as a mediator has spoken to the judge who went on to deal with the trial. And in the fairly small number of unsuccessful mediations I've had, I simply do not know what the result of those cases have been. The mediation file is separated from the trial, from the continuing case bundles, and never the twain shall meet. Residential property division of the first tier tribunal offers the same service, but mediations are just rarer there. There's a number of reasons for that. The tribunal does a lot of quasi-regulatory work or appeals. Well, local authority is never going to mediate on housing standards or rent repayment orders. Even where there's straightforward inter-partes dispute like service charges in residential leases, the impulse to save costs is perhaps less pressing. The sums might be trivial, but the important thing is the tribunal is simply not a cost-shifting tribunal, so there's no penalties associated with taking the matter to a hearing. Indeed, it's so distinctly not a cost-bearing tribunal that some of the applications are designed to stop cost shifting under contractual arrangements. So stopping landlords, the tribunal has power to stop landlords adding legal costs to service charges or for treating them as administrative charges. Tribunal does recommend mediation at times. I've done service charge disputes which have been mediated. Sometimes you get the impression that they're referred for mediation because the tribunal just doesn't want to have to face such a long and difficult process as some of the service charges disputes it gets. But there's an ongoing relationship between the parties that can be positive for mediation, but it can also lead to frustration. I've certainly mediated a case where the applicant settled their case and then 2 weeks later issued a new application in relation to the following year's service charges. Representation generally rarer in the first tier tribunal residential property division, and that can create its own difficulties. Moving on then to the courts, the tribunals don't offer early neutral evaluation, but the courts do. the courts have a long and inglorious history of offering a form of early neutral evaluation. That's where you turn up for an interim injunction or to contest an interim injunction, and the circuit judge starts shooting from the hip over what they think a court is going to do in the end, and to shout at the parties appropriately or inappropriately. And that can be a very frustrating experience. What I'm talking about here is early neutral evaluation as it is positively known, and as it was introduced in the CPR in 2015, where it is and it has been characterised as a simple concept which involves an independent party with relevant expertise expressing an opinion about a dispute or an element of it. Now, the advantages which are typically seen from this is that it can break a deadlock by providing an unbiased opinion, focuses the mind. If one party has unrealistic expectations, then they can be disabused of those, and they can be given some insight into what is likely to and not likely to attract court. Protects confidentiality, clarity, and speed. But it does have real problems, and I think it's noticeable that it's not that much used. Winners tend to become more entrenched in their position, less likely to negotiate. Losers can become retrenched, and their position is positive. It takes quite a lot of time and money, particularly if it's done through the court with directions and matters of that sort, and it can be disproportionately expensive. And generally, because the court will not allocate huge resources to this, it can be difficult to resolve complex factual or complex technical questions. And then finally, if you've got a small cohort of judges in a particular court who are dealing with this matter, then you might find that your favourite judge or your preferred judge is the one who's excluded from further involvement because they're the one that's offered an opinion. Chancery Guide and the TCC Guide both include early neutral evaluation schemes, and the Commercial Court also has a non-binding scheme. Chancery Division directions will be up to the judge, or those can be negotiated. It's acknowledged that this can be done on paper, but a half-day hearing, usually without prejudice, potentially binding if the parties wish it to be, can be offered. Frankly, in my experience, the only circumstance where I can see early neutral evaluation being attractive is where you have a high-value dispute, where it really is locked horns on say, construction, particularly lease covenant, some rights or other. Then early neutral evaluation might be of value, but otherwise, I think the downsides are often too profound. And that's where FDR really comes in. FDR borrowed from the family courts in money matters, introduced into chancery courts, and I think generally very effective. The judge acts as a facilitator or mediator, but may provide an opinion about the claim or elements of it. So it has that useful bit of early neutral evaluation without necessarily the same extensive framework. You still have bundles, you still have position statements. In fact, you need position statements because you want to make sure the judges appreciated the strength of your case. You can even have expert evidence which isn't necessarily CPR compliant. That can be acceptable in these circumstances. It seems to me that it works best when an opinion can be invited and could be warranted. Again, perhaps a particular point is particularly weak on one side's case and they're refusing to acknowledge it. But often I think it works more effectively because there's this kind of sword of Damocles over the parties, or perhaps more particularly over their advisors, that if they don't negotiate and mediate an agreement before they get in front of the judge or before the judge holds forth on the opinion, then they might find that their position is exposed or their worries start to eventuate. And then the final advantage really over, and this is an advantage over tribunal mediations as well, is that the judge can potentially make an order there and then. That tends not to happen in tribunal mediations. And it's promoted in the various guides and white books as particularly good for trusts of land, appointments of trustees, disputes, beneficial interest, matters of that sort, inheritance, partnership claims. And certainly I would endorse that view. I've certainly used it successfully in trusts of land particularly where there's been expensive but disproportionate risk of cost in two ways. One, that the actual value of the trust is just being diminished by the dispute and will come to nothing, or come to significantly less than it would do if it's nipped in the bud. And secondly, in circumstances where there are a lot of other peripheral, not real property issues, but personal property issues, which are looked to be solved at the same time. And that's not unusual in a domestic quasi-family dispute circumstance. So, in conclusion, private mediations, in my view, still have very much a place, not least because courts don't really offer mediation per se in the way that tribunals does. You get to choose a mediator, you get to choose the location, you get freedom, greater freedom of process. In my notes, I've got a phrase saying that the process feels less terminal. I think actually in a private mediation, the parties are more in control and the mediator is more subordinate to the way that the parties want to conduct it. Tribunals, the judge is used to having it their way, and it is a free service, and they to some extent have the whip hand over things like timing and plenary sessions, matters of that sort, where the parties might want to be more flexible. But the downside is that you have to pay the mediator, and you normally have to pay for the rooms. So going forward, it seems to me that early neutral evaluation is going to remain niche, basically. And FDRs are going to be here to stay. The tribunal, it seems to me, might be better off in offering a choice of mediations than FDRs, but I don't think that's in prospect at the moment. And so the way forward is the way really that things were developing just before the pandemic struck. I think we're going to see continued use of tribunal services. I think that's a positive. I think they're going to be important to approach those with a clear eye on their advantages and disadvantages. But at least with tribunals and with perhaps FDRs as well, you have a circumstance where there is a form of ADR, form of negotiation, which is mediated and facilitated, which is cheaper than the private mediation service. So thank you very much. I will now have a look to see what questions we have. Perhaps Raghav can assist with that as well.
We do have a couple of questions, Tony. If you click on the Q&A button, there's
I'm showing my poor skills at the moment. I think hang on, that's it. Right, got it. Doesn't have, and this is true in land registration and residential property in particular, it can't enforce its own orders. Now that is being massively improved upon as tribunal judges start sitting as district judges at the same time, particularly in residential property, so two-hatting as it's sometimes called. They can not only make an award in the tribunal, but they could then make an order that is payable. But at the moment, particularly, and this is particularly in land registration, because you can't enforce the terms of a contract through the tribunal, it's not within the jurisdiction of the tribunal to do that. You can't have Tomlin orders, basically, and the tribunal won't accept Tomlin order. The powers of the tribunal, particularly in land registration, is effectively to either approve or reject the reference, the matter which has been remitted to the tribunal. The tribunal does have a power to give direction, so it can direct, for example, in boundary disputes, a determined boundary might be slightly different to the one that the parties have contended for, and that can be directed. But they don't have, tribunal judges don't have the power to enforce the contract. And in land registration, at the moment, it's unusual to sit as a district judge as well as to sit as a tribunal judge. And typically in residential property, you don't. unless it's been a matter which has been referred from the county court. So we will have to see whether double hatting leads to a circumstance where perhaps an order can be made in court proceedings, but unless it's started in the court, or unless it's got that link with the court, you can't enforce a Tomlin order through the tribunal. You have to enforce it as a separate contract.
Thank you, Tony. And I have one question also, which is how does limitation apply to proprietary estoppel claims? So we know proprietary estoppel is an equitable regime. It's an independent cause of action. So therefore, we need to look at the equitable regime for limitation also, which is essentially the doctrine of laches and acquiescence. This is laid down, I believe, in section 36 of the Limitation Act 1980, which refers back to that regime. But essentially what the court is looking at is whether or not the claimant who seeks the equitable remedy has come to the court quickly enough once he or she knows that his or her rights are being infringed. It's worth noting that mere delay isn't enough, but you have to show some sort of detrimental reliance upon that particular delay by the claimant, by the defendant. For example, giving the impression that he or she is the owner of the land, or that there was no issue in respect of the rights which the claimant is now bringing up, which has led to some sort of detriment. That could be, for instance, a hazy recollection of events after a number of years that have gone by, or for example, the destruction of any documentary evidence. So it's a matter of delay and whether or not the claimant has sort of acquiesced in the position and the defendants relied upon the same. So that is the position that one, or the doctrine that one must look at when considering proprietary estoppel and limitation. I believe that's all the questions we have, Tony. Unless anyone else does have any questions, feel free to drop it in the box, or alternatively, you have our email addresses, or do contact Chambers. I will endeavour to get back to you as soon as we can with the answers.
Yes, I'd like to thank everyone for attending. I'd like to thank patients as well over the sound issue which we had at the start. I'm very sorry about that. We'll try to make sure that that doesn't happen again.
I do apologise on my behalf. I do not know what it was. Do believe me when I say I've not messed with the technology at all. Simply my MacBook might be throwing up some problems, or it might just be the internet connection. But I do apologise for that inconvenience. But again, thank you very much for attending.
Yes, thank you for attending. Thank you.